Good morning, Mr. President and honorary members of the panel. My name is Brandon Zhang, and I appear on behalf of the respondent, the Games Disciplinary Committee. I will be speaking for 7 minutes and respectfully reserve 1 minute for rebuttal. I will make one submission on a procedural issue. We submit that South Nankaland was lawfully chosen to be the tribunal, and that it was lawfully chosen for two reasons. First, it was reasonably practicable, and secondly, there was no procedural unfairness. Pursuant to Rule 23, subsection 2 of the qualifying games, the tribunal shall be set up within 1 week from the end of the tournament, where reasonably practicably to do so. If I may direct the panel's attention to paragraph 25 of the record, here it states that a day after the tournament, there was massive riots in the city against the government, and that the riots subsided after 3 days. This is also reflected at clarification number 22 of the record. In the present case, given the circumstances of the case, it was a matter of safety to leave the country as soon as possible. And this was practically reasonable to do so for two reasons. One, it was not known exactly at the time how long that the riots would continue to last, whether it was 3 days or months on end. The athletes had no reason to believe that it would only last for a short period of time. And two, they did not know, even when the riots would stop, whether another riot would continue or restart. At paragraph 29 of the record, it states that the hearing was held in the Global Games headquarters in South Nankaland. And this is an Oceania country. We submit that merely because it was where the Global Games headquarters was located, that does not mean that there was any impartiality or unfairness to appellant. It was chosen because it was the most convenient place to hear the dispute, because the relevant parties included the qualifying games medical team, the games committee, and the International Video Games Federation. It was practicable given the situation for a timely tribunal to be set up and to adjudicate on the dispute. In addition, South Nankaland is an Oceania country, and Ms. Tangs was also born in an Oceania country and holds citizenship in an Oceania country. According to clarification number 16, when parties disagree on the location of the tribunal, the GDC will have the final say in determining the location of the tribunal. And therefore, the GDC was within its rights to hold the dispute in South Nankaland. Any attempts by the appellant to argue otherwise would simply be bare assertions, and there's no evidence on the record to prove so. According to clarification number 20, evidence was formally submitted and the parties were informed of the location of the hearing. If I may direct the panel's attention to paragraph 33 of the record, The GDC reviewed both party submissions, the anti-doping reports, and heard both sides' oral statements. Therefore, in the present case, there has been no procedural unfairness, as appellant had been given the equal opportunity to make out its case. It was heard before the courts. And even if the panel found any procedural unfairness or irregularities, nevertheless, the panel has full powers to proceed and adjudicate on the dispute today. According to Article R57 of the CAS Code, which provides that the panel shall have the power to review the facts and the law, and has the full power to review the facts and the power to establish not only whether the decision of a disciplinary body being challenged was lawful or not, but also to issue an independent decision based on the respondent's rules. And therefore, we submit that first, there had been no procedural unfairness, but even if there was, Article R57 will cure that defect, and the panel today can decide on the merits of the case. If there are no further questions from the bench, this concludes my submissions. Thank you, Mr. President and honorary members of the panel.